Thank you, Anushka. Hello, everyone, and welcome to our webinar. Just a couple of words about media defense. It's a primarily legal organization. We're based in London, but we work globally, and what we focus on is assisting journalists with legal defense. You did through grants and through strategic litigation and occasionally through capacity building events and events like this one. We are organizing this particular webinar jointly with the International Press Institute. Maybe, Grace, you want to say just a couple of words about IPI before we just move on to the topic of this webinar.
Sure, thanks, Yuri. Hello, everyone. It's great to be here. My name is Grace Linczer, and I manage the membership program and engagement work at the International Press Institute, or IPI. First, I just wanted to give a big thank you to Media Defense for hosting this webinar with us and for inviting all of the IPI members to be part. It's great to see some of you here with us today. I'll give a longer kind of overview of the IPI membership program at the end. I don't want to take up too much time, but generally speaking, I just wanted to intro IPI. So the International Press Institute is a global network of editors, media executives, and leading journalists from around the world. And together we work to defend media freedom wherever it comes under threat. Our mission really is to defend the free flow of news wherever it's threatened. And so this topic that we'll be discussing here today is very relevant to this work. So I'll say more later, but I think with that, I just want to thank the Media Defense team again and our wonderful speakers for joining us. And I'll pass it back to you, Yuri.
Fantastic. Thank you, Grace. Today we are having an amazing panel of speakers to discuss something of an emerging issue. I mean, it's not entirely new, but we're dealing with, with a topic that is quite complex and it's still evolving. And it is about so we're going to talk about the intersection of data protection and freedom of expression, and how the increasingly strict regime of protecting personal data influences freedom of the media. And, spoiler alert, it's actually, the picture is not good. The impact is quite negative, and I think we'll hear at least a couple of case studies about how data protection is being misused by bad actors to suppress public interest journalism. I mean, again, it's not news to anybody attending this webinar that these are difficult times for freedom of expression and for media freedom, and not just in countries where it's always been very difficult for independent media to exist, but also in so-called established democracies. Freedom of expression is being eroded pretty much across the board, and it's often done in the name of protecting other rights. And of course, freedom of expression is not absolute, so some restriction is possible, but the question is how far you go with that. And one of these threats now is cloaked in this, concern about personal data. And I'm not going to go into detail about it, but in Europe, at least, we've been going through a kind of moral panic about personal data, especially how it's being used kind of online, has been harvested and used by online platforms, but also about surveillance, etc., etc. And our panel is going to be a bit Eurocentric, even though I see that the audience is really global and diverse. But it is justified because Europe has been, for better or for worse, has been leading the way on data protection. And the regime established by the European Union, it has extraterritorial influence, and it has been copied by many countries outside the European Union. And, the EU likes to brag that they are world leaders in regulation. I'm not sure it's much to be proud of, but, this is where we are. And anyway, so we'll, in terms of our speakers, so we'll open with a kind of overview of the European data protection system and how it impacts media freedom. And this will be introduced by Melinda Rucz, who's a PhD researcher at the University of Amsterdam, and freedom of expression, media freedom is her area of specialization. We'll then hear a couple of case studies from two investigative journalists, award-winning journalists from Turkey and Serbia, who will discuss how data protection has been used against them. Sort of legal action has been taken against them in response to their legitimate and publicly important reporting. So that will show actually how now these laws are being misused in practice. And we'll also hear from Beatrix, Vissy, who represents one of our partner organizations, the Hungarian Civil Liberties Union, and she will discuss this situation in Hungary, the litigation they've been doing in this area. And Hungary is an interesting country because there are we see that in Hungary, the data protection laws have really been weaponized and really widely used against media, independent media, and kind of public interest reporting, and used by powerful actors, powerful businesses. And we also see that the legal system in Hungary is quite deficient in this respect. It doesn't provide enough protection to freedom of expression, and yet this is something that is to some extent enabled by the EU data protection regime that is not perfect either in this respect. So then, without further ado, over to Melinda. As I said, Melinda is a PhD researcher at University of Amsterdam. This topic is something that is bang on within her area of expertise, and she will kind of set this scene, set the context. Yes, it's focused on in Europe, on the European Union, but as I said, it's been used as a model for the rest of the world. And now in Europe, this is where I think we have kind of the most developed system of protecting data protection, personal data, sorry. So Melinda, over to you.
Yes, thank you so much for the introduction and the invitation to speak at this event. I'm very happy to kick off this panel. I have been researching this topic of the impact of data protection law on journalistic freedoms for quite a few years now. It was indeed a bit under the radar for quite a while. Also, while the GDPR was drafted, the European data protection regulation, there was not a lot of attention to how this will affect journalistic freedom. So I'm happy to see that there's more engagement with this topic now. In my presentation, I hope to give a brief introduction to the legal framework of strategic litigation against public participation, and in particular data protection-based abusive lawsuits. So SLAPs stand for Strategic Litigation Against Public Participation. These are essentially lawsuits that are initiated with the goal of discouraging or punishing participation in public debates. There's typically a significant power imbalance between the initiator of the SLAP, which tends to be a wealthy businessman, a powerful political figure, and the target of the SLAP, which tends to be journalists, human rights defenders, or NGOs. Legally speaking, these sort of abusive lawsuits have always been very difficult to tackle because they masquerade as legitimate lawsuits that seek legitimate enforcement of a right, while in reality their goal is not really to get a favorable judgment in the courtroom, but just to eat up the time and the resources of the target. Defamation law has been the main and traditional legal domain for these abusive lawsuits. So the classic SLAP would consist of a legal claim that is filed by, for example, the subject of a news report complaining of damage to his reputation. And of course, there can be very legitimate reputation damage claims. But what brings these lawsuits into the SLAP space is that in these cases, it is manifestly obvious that the goal is not to enforce a personality right, but to silence the target. And in the last 5 years, as Yuri already has said, we see a new shape of these SLAPs emerge where it's not defamation law that is primarily used, but data protection law or the combination of the two. Data protection law in general is very susceptible for this type of abuse because basically the entire life cycle of journalistic work involves processing of personal data. So you might call conducting an interview with an expert a news gathering activity, but in the eyes of data protection law, this is just another instance of personal data processing, which then brings this activity within the realm of data protection law. I'll mainly use the EU's GDPR as the main reference point, but as also Yuri explained, this of course also has relevance beyond Europe. The GDPR itself has a very broad definition of what counts as personal data, and also a very broad definition of what counts as personal data processing. And this was very much the goal of the EU legislator, to cast the net very wide, to establish a very high standard of protection for personal data. But what we see is that this very wide net that results in a very broad tension with other rights, including the right to freedom of expression. So what does it mean in practice that journalistic activities fall under data protection law? Well, it means that there's a lengthy list of obligations that journalists have to comply with in the process of their work. And some of these put very serious strains on freedom of journalism. And I wanted to briefly highlight 3 areas of data protection law that are the most prone for abuse and where we also see these sort of tension points arising. First of all, a key aspect of the GDPR is that every data processing activity has to have a so-called legal basis. The GDPR lists 6 options. For example, data processing can be based on consent or on the basis of performance of a contract, but there's not really a tailor-made option for journalistic data processing. So this is one of the areas where we see abusive claims popping up, where the claim is that journalistic data processing does not have a valid legal basis. The so-called data subject rights are the second area where we see tensions. The GDPR grants data subjects, so the persons whose data is processed, a list of rights. For example, they can request their personal data to be deleted. And of course, this can very much go against journalists' abilities to, for example, publish stories. And the third problematic area is the power of data protection authorities to enforce personal data protection. The GDPR really arms data protection authorities with very expensive powers. For example, they can request a bunch of information regarding data processing, for example, the source of information, which then can conflict with the special protection of journalistic sources. But they can also, these authorities can also impose very high administrative fines, and this can, of course, be a very powerful deterrent to critical reporting. The GDPR does recognize this tension, and it has a dedicated provision to journalistic expressions, Article 85, which is also sometimes called the journalistic exemption. This provision basically provides a basis to exempt journalists from certain GDPR obligations, but this provision is phrased in a very general manner and basically leaves it to EU member states to define the scope, to decide what sort of activities count as journalistic activities and what sort of provisions journalists can get out of. And this hands-off approach from the EU was necessary because the EU in principle does not have legal authority to legislate on journalism, but then this sort of hands-off approach is also what leads to already a very uneven balance between the right to data protection, which is given very detailed and high-level standards in the GDPR, and the right to freedom of expression, which is regulated in a very general manner without any specific safeguards. EU member states have taken a lot of different approaches to implementing this provision, and we have basically everything on the spectrum from very broad journalistic exemptions. For example, in Sweden, basically the entire GDPR is disapplied if its application would conflict with the right to freedom of expression, while some other member states have taken very restrictive approaches to defining what counts as journalistic activity that can merit an exemption. For example, we can see this in the Romanian implementation, and some member states have just not introduced any exemptions at all, and that is the case that we have in Hungary. And this is the key concern from the perspective of abusive lawsuits and SLAPs, that due to the flexibility that the GDPR lends to member states on this topic, some national implementations are so vague, so narrow, or even non-existent that the GDPR can be effectively used to target and silence journalists in ways that clearly violate their right to freedom of expression. And it is not just that this is a new instrument in the toolbox of those who want to target journalists, but the GDPR is actually a uniquely convenient instrument for this because of a number of structural characteristics of the GDPR and the data protection law in general. For example, the high fines that I already mentioned earlier, but also just the fact that the GDPR allows SLAP initiators to use these tandem proceedings of both going to civil courts and also to data protection authorities with the exact same claims, which then of course adds to the burden on journalists. As a closing point, I want to point out that although I focused a lot on the GDPR's internal mechanisms to balance these two rights, we also have another EU instrument on the horizon, the Anti-SLAPP Directive. And while on its face value, the directive does not seem to be tailored to address this sort of data protection-based SLAPs in specific, we have to wait and see if member states may implement more general anti-SLAPP safeguards that can also provide some legal pushback against data protection-based SLAPs. With that, I'll give the word back to Yuri. Thank you so much for your attention, and I'm looking forward to hearing the rest of the speakers.
Thank you so much, Melinda. Yeah, I just maybe need also to encourage everyone to post any questions as we go. I forgot to mention it. So if there's anything that's, kind of, you have any kind of follow-up question, reaction, you can type it up right now in the dedicated section for, questions and answers. And we have a Q&A session kind of reserved for the end of the webinar, but for maybe some follow-up questions, I can just put them to the speaker straight away if something is to be clarified. But Melinda, yeah, thank you so much once again, and I think it's as I see it, if we read it, kind of take the existing data protection regime to its logical conclusion, if there is no journalistic exception implemented in a particular country, and we have countries like that, or where this protection is weak, then you can actually make journalistic work impossible, because obviously journalists deal with data all the time, and there doesn't seem to be a clear, kind of line. It seems to be more like, when we don't really have, in countries like, the UK, it's just based more kind of in common sense and the kind of inertia when you kind of think, oh, but of course, like a journalist, journalistic work is different, but we see like what can happen if you don't have this kind of robust protection for media freedom, for freedom of expression, vis-a-vis data protection. So we see what can happen in Hungary, for example, and we'll discuss Hungary later, but it's just but this is something that can happen in many other countries. So this is why we're doing this webinar, because I think bad actors, they learn from each other sometimes much faster than kind of activists or human rights lawyers. And if this strategy works in one country, we'll probably see it, also used in other countries as well. And it is used, for example, in Turkey. And our next speaker is Hazal Ocak. She's a freelance journalist from Turkey. She's been reporting on human rights issues, environmental issues, climate, and obviously, as investigative reporters, she suffered consequences for her reporting, and she will talk about one case specifically when I understand her reporting on that related to a high-ranking official, unquestionably kind of an example of public interest journalism. It led to data protection-based legal action against her. So I will let you, Hazal, just talk about it yourself. So over to you.
Hello everyone. I am very happy to be part of this webinar, and thank you so much for inviting me. A brief introduction about me was just chariot, but I would like to start by adding something. Due to several investigative reports I have written, which have received awards, I am currently facing 7 lawsuits, while I have been honored with 14 journalism awards over the past 5 years. I have also been targeted by a series of celebs lawsuits. Altogether, I am facing up to 18 years in prison and hundreds of thousands of Turkish lira in compensation claim. And today I will focus on one particular investigation, which is the most striking, and also it is directly related to the theme of this webinar. The story itself and the legal aftermath are quite complex, but I will try to summarize them for you. If you would like more detailed information about the lawsuit after the session, I will share my contact info at the end. You are always welcome to reach out. Let me start with a bit of context. If you have ever been to Istanbul, you have probably seen the Bosphorus, it's must see. If not, I strongly recommend you visit it due to its unique beauty and historical value. This area is protected by a special law. You are not allowed to build any houses, gazebo, fireplace, even garden features without special permission from the Istanbul Metropolitan Municipality. Enforcement is handled by municipality inspectors. Fahrettin Altun, the head of Turkish Presidential Communication Director, lives in a neighborhood along the Bosphorus called Kuzguncuk. He rented a public piece of land nearby from the General Director for Foundation Estate Institution for just 258 Turkish liras per year for 10 years. That's about €5.50 per month at today's exchange rate. He then illegally built a pergola and a fireplace on the land. On the 13th of April 2020, municipality inspectors demolished these structures because they were against law. Residents of the area tipped me off about the illegal construction. They had also filed a complaint with municipality. After weeks of investigation and document review, I wrote my news. The article you've seen in the image is the result of that works. So shortly after the article was published, I became the target of a smear campaign in pro-government media outlets. At the same time, I was subjected on only harassment on social media. Even before I was officially notified, these media outlets claimed that I had published Altun's address and that I was under investigation for targeted a public official fighting terrorism. Not only myself, but also the editors who approved the story and the photojournalist who took a distance picture of the area were accused of terrorism-related charges. In reality, I never published Altun's open address, and more importantly, he is not a public official involved in anti-terrorism operation. Eventually, I was acquitted all of charges in that case. What is more, Altun filed multiple compensation lawsuits against me, which were rejected, although two are still being appealed. Altun also filed a complaint with the Turkish Personal Data Protection Authority, called KVKK, on the 7th of July 2021, claiming that my report violated his privacy and exposed his personal data. Now, let's take a closer look at the KVKK process, which is central to this webinar's topic. Before the session, I revisited all the relevant decisions and consulted my lawyers to make sure I am sharing the latest updates. Altun's lawyers submitted several arguments in the KVKK complaint. He claimed the article lacked public interest and was false. He argued that Altun's personal data had been unlawfully processed. He said the report included Altun's address, location, and photography. He referred to court-ordered access ban as evidence of violation. At most concerning, he denied the disclosure of our news source. Our lawyer submitted a defense statement to the authority. They argued that Altun's complaint was unfounded and that the article was both truthful and in the public interest. They also state that no specific address or personal photo of Altun's was published. In fact, the land had been rented through a public tender and the address had already been disclosed to the public. Our lawyers also point out the Altun's address was actually spread by pro-government media, not through our article. They emphasized that the report falls under the freedom of the press and expression and the public has a right to know. They reminded the board that Turkish press law protects journalists from having to reveal their sources. As a result, KVKK ruled in our favor. The decision stated that the article did not publish an open address. The report served public interest. It fell under the freedom of expression and press. As a public figure, Altun's rights were not violated. The report was factual and timely, and press freedom outweigh personal right in this case. However, the legal battle didn't end there. Altun's lawyers sued the KVKK for this decision. In their petition, they again cited the access ban as evidence of a violation of Altun's personal right and request the reversal of the KVKK's favorable decision. Unfortunately, Ankara Administrative Court ruled in favor of Altun and nullified KVKK's decision. So the legal process is still ongoing. Now let's take a closer look at this access ban, which was repeatedly used as a legal argument. Immediately after my article was published, Altun's lawyers petitioned Istanbul Anadolu Criminal Court of Peace, requesting an access ban for both my report and other media outlets that share it. Shockingly, the court granted the ban and justified it with a completely unrelated argument. The verdict states that my article was aimed at undermining Turkey's success in fighting COVID-19, especially compared to European countries. We appealed this absurd yet serious ruling to the Turkish Constitutional Court, which ruled in our favor. The access ban was lifted and the state was ordered to pay me 18,000 Turkish lira in damage. So far, I have tried to explain the problems I have encountered in the legal issues I had to face. Now I would like to briefly talk about the personal and professional impact of this process. Everything began in 2020 and it still hasn't ended. In the early stage, I often felt deeply stressed and sometimes very lonely. There were days when I would attend an award ceremony in the evening for my reporting, then go home and prepare my defense statement for court the next morning. This circle continued for quite a while. At one point, I was spending more time in courtrooms than in newsrooms. Moreover, even people who shared my article or commented on it were sued by Altun's legal team. It's been an exhausting and emotional draining experience from start to finish. Unfortunately, I am not the only journalist who has struggled with legal issues. This is not in Turkey. Many journalists in Turkey face similar or worse repercussions simply for doing their jobs. In fact, several of my colleagues have been jailed recently just for reporting the truth. There is ongoing effort to immediate journalists and create a climate of fair. I believe press freedom and freedom of expression are more under threat now than ever before in Turkey. But I remain hopeful. Like many of my bro colleagues, I will continue to defend journalism and insist that journalism is not a crime. Thank you for listening. If you would like more details about the legal process or my work, please feel free to reach out to me anytime using the contact details on the slide. Thank you.
Thank you so much, Hazal. And I think it's just really such a striking example of this, kind of strategic litigation against public participation, SLAP, and we see how the subject of your report, how he used multiple avenues, and all of them sound pretty ridiculous and far-fetched. And finally, it seemed like this, data protection, this is where it's stuck. So, this is kind of the strategy, kind of throw everything at the wall, and sadly, data protection is like the weakest link. So, all the other claims he tried to pursue, they failed, but this one still, this particular case goes on, and it's been such a long time. And And, you know, when it comes to slaps, this is what happens, that it doesn't even matter that much whether there is, you know, the claim against the journalist has some basis. You know, it just drags on, and even if, you know, the journalist wins in the end, so many resources, energy has been, you know, have been expounded, you know, and that is what, you know, those kind of bad faith actors, this is what they want to achieve when they use slaps. So it's a kind of double whammy. So we need better laws about data protection that respect freedom of expression, but we need also additional safeguards against slaps. And as Melinda said, you know, it used to be just defamation, but now data protection is increasingly used, you know, for this kind of slap action as well. But it's, I mean, it's a good example to illustrate how it can be misused, but, you know, it's also like a very depressing one. But thank you very much for sharing it. And we also have investigative journalist from Serbia, Bojana Jovanović. She's a deputy editor and co-founder of a Serbian investigative outlet called KRIK. So they're quite renowned for their investigative reporting, but obviously it lands them into legal trouble all the time. And again, data protection is something that has been used against KRIK. We've supported one of the cases, but there are probably more such cases. And I'll just, I'll just give the floor to Bojana to just to share her story and provide another example of how data protection laws are kind of weaponized against investigative reporters.
Thank you,
So
Yuri.
over to you, Ben.
Thank you. And hello, everyone. And first, I'm so sorry because my voice is a bit weird because I woke up with some throat issues. So this is not my real voice. If I sound like a robot, that's not usual. Thank you for having me. And as colleague from Turkey said, we all have similar issues and similar problems. And as Yuri said, bad guys are copying each other, and they are spreading the bad practices actually like really fast. And we in Serbia, we copy Turkey, but we also copy Hungary. So, you know, like it's not a good position for investigative journalists. Just you represented me, but just to say that what we are doing at KRIK, we are one of the basically most prominent investigative outlets in Serbia, and the focus of our work is basically investigating organized crime and ties between organized crime groups and people from the government and people in power. But also we are investigating corruption. So basically we do organized crime and corruption stories, and we are monitoring public officials, and we try through our investigations and through our reporting to raise transparency a bit. And we all know that nowadays the transparency is basically shrinking everywhere. So because of what we do, we are facing problems since the foundation of the organization, and we are 10 years old organization, and we are facing the same problems basically as the colleague in Turkey mentioned. So we also had like our journalist, editor-in-chief. We've been targeted by smear campaigns. Public officials were, you know, trying to discredit us in their public statements, in their press releases, or, you know, like when they're somewhere on the television, like hosting some shows. So they try to present us as bad guys. We also have Secret Service on our back. So we know that we have been monitored for years, and that our office is wiretapped, and that we need to be really careful when it comes to investigations, and especially when it comes to keep sources safe. And the last, I would say, mechanism, the government and people, bad guys and people in power, and people who are close basically to the ruling party here in Serbia, are using against investigative and independent media, and especially against KRIK, I would say, are slaps. So currently we have 17 ongoing court proceedings based on slaps, and it's the court proceedings are lasting for too long, and you know, as it was mentioned, it's really hard to work when you're facing this, because you need to invest a lot of energy, a lot of time, a lot of money to fight back, and to go to courts, and you know, to try to fight back and to win the cases. Who is basically, so one of the crucial questions are, who are those bad guys? And usually those bad guys are people, politicians, or people close to them, as I said, like oligarchs, people who are maybe members of the inner circle of our president of the country, who is the most powerful basically figure in the country. But also some organized crime members who are basically close to the government and who are protected by the government. So basically, these are the profiles of the people who sued KRIK in the past 4 years, because we are facing this problem since 2021. And among them are also, which is interesting, are public officials. So, for example, we had received slaps from minister, ex-director of Secret Service, then some policemen who are commanders of police units. And the case that I'm going to present is, I would say, one of the most infamous cases currently in the country, is the case that where the lawsuit is issued by a judge. So basically, as Melinda said at the beginning, most lawsuits are filed for defamation and violation of the presumption of innocence, because we report about organized crime. But we also have this, and this is the latest cases, are that slaps are filed for violation of privacy, basically, and privacy data. So what's the story with the judge? The judge of the appeal court in Belgrade, her name is Dušanka Đorđević, together with her husband, who is a lawyer, have filed 2 lawsuits against us. One was civil, and by this civil lawsuit, they are asking for, of course, for money, and it's approximately, it's not a lot of money. It's approximately 6,500 euros. But they, besides the civil lawsuit, they also issued a criminal one, which is really problematic, because they ask for two things. They ask for 10 months of prison for a journalist and editor of KRIK, but also they ask for 2-year ban of doing journalism, basically of practicing journalism. And those 2 lawsuits, the judge filed because we published a database about judges. It's called Judge Who Judges. And in this database, we published it in 2020. And we basically published the profiles of the most prominent judges in Serbia. In those profiles, we gathered and we published the information about the career of judges, but also the most important cases where they made decisions, also what kind of decisions they made. But we also looked into the property of the judges. So basically, it's a combination of their work and, like what they own, their real estate. And the idea of publishing the database was, as I said at the beginning, to raise the transparency in the country. So basically, judges here are like really protected, and nobody before us reported about them. So when we published the database, before publishing it, we reached out to the judge, and we reached out to have an interview or to send her questions about our findings. And she refused to comment, and she basically threatened us that we are doing a crime, and that if we decide to publish data about her, that she will sue us. And that happened basically. So I said that we are facing now 2 lawsuits, and the court cases are just ongoing. And so basically, what is she saying in both lawsuits? She's claiming that we violated her privacy by publishing her name and position in the court. And her name and position in the court are already public on the official website of the court itself. And all trials in Serbia are also public, so anyone can go and be there and report from the trials. It's not forbidden; they are closed just in some cases. So basically, that's the first thing she said. And another thing is that she's claiming that by publishing the information about her property, we put her in danger, and that we are basically helping the criminals to find her. So that we put her safety that now she doesn't feel safe anymore. So this is important because we just published, we didn't publish any data that could tell anyone where the property is. We were published just like the parts of the cities, one part of the Belgrade, and it's huge. We didn't publish streets or a number of the apartment or anything close to that. So basically we were really, really careful. But anyway, she is saying that basically we put her in danger, and she's really claiming that we made her a lot of problems by publishing those information. So the cases and the lawsuits are basically based on these 2 claims. So they're not so complicated, but they're raising a really big question here in Serbia, because if we cannot publish a name of a public official, and if we cannot report from trial where public official is basically holding the trial, basically we are now in position to defend not only our work as KRIK's work, but also the legal right of journalists to write about the people who are in power and who are on public positions. And now there is a question. It's basically we are defending the right of journalists to report from trials in Serbia, because if we lose these cases, then it will mean that nobody in Serbia can basically mention the names of the judges and not even analyze their work, which I think is really important, because the basic journalistic task is to monitor the work of the people who are in power and to look into their assets, because we all know how corruption works. I will just shortly maybe say a few things how we fight SLAPs, because that can be also maybe of use for some people who are here listening to this. But just before that, I want to say that a colleague from Turkey mentioned all the problems related to stress and financial pressure and time and energy consumption. But this is also when it comes to this case particularly, where we are into the courtroom, we are fighting the judge. It's our positions in the courtroom are not close to equal, because she is at one hand she is public official, and another important thing is that her colleagues are the ones who need to bring the decision. And it's it's hard to be fair in in those cases, I would say. And another thing in Serbia, and I think in all the country that are facing a lot of slaps, is that judiciary here is under huge political influence. So it's really easy to lose the case, even though you've done like brilliant reporting, and we have fact checking, and we have legal experts who are reading the stories before publishing. But like if there is this political influence, then you cannot be sure that the justice will be served. So I just want to say a few things how we fight back. So what we do, and that's where Yuri, your support is coming, is that we have independent international observers on our trials. So basically, we call people representatives of different variety of media and journalism organizations and associations. So they are coming there to be present as observers, because all trials are public, and judges are acting differently when there is public in the courtroom and when there's no one, just like the both two sides. What we also do, we report about our lawsuits and trials, so we inform public what's going on to us, and I think that's really important, because it's really important when it comes also to the financial support, because we can raise money for trials. We continue to report on people who sued us. So we are showing them that the slap didn't work, basically, and that they didn't frighten us, and they didn't stop us from working, for doing our job. And what we also did is that we created an anti-slap network with other colleagues in Serbia who are facing the same problems. So we support each other. We go to each other's trials, we report about it, and we also investigate together the bad guys who sued us. So we are kind of trying to slap back through the reporting. Sorry if I took a lot of time, but I tried to be short, but it's hard because it's like really important topic, and I think a lot of people are actually now facing in Europe, but also globally with the same issues, and I hope you'll have questions later. Thank you.
Thank you so much, Bojana, and yeah, thank you in particular for sharing also these kind of strategies that you're using, which I think is useful for other participants, especially journalists, to to learn more about. But yeah, it's kind of sadly just another example of how now investigative journalists can be targeted by by public officials and other influential kind of influential powerful figures, by just by using this kind of EU data protection model. I will kind of let's move to our final panelist, Beatrix Vissy. She leads strategic litigation, the strategic litigation program at the Hungarian Civil Liberties Union. And they've been, well, I know because, this is our partner organization. So at HCLU, you've really had a lot of cases that, data protection cases against different media outlets. So it's been really actively used, by various interests. But you've been also kind of reasonably successful. I mean, there've been some successes, let's put it this way, along the way. So, so I think Beatrix will be also able to share maybe some arguments, some strategies that have worked, and which again would be very useful indeed. So over to you, Beatrix.
Thank you, Yuri, for this kind introduction and for having me and the Hungarian Civil Liberties Union. I'm really glad to be here and to share some of our experience in dealing with GDPR-rooted slabs. For those who are not familiar with my organization, the Hungarian Civil Liberties Union is a human rights NGO founded in 1994. And since then, we have been working to ensure that everyone is informed about their fundamental rights and empowered to enforce them. And I also have a PowerPoint presentation I'd like to share with you. So I hope that this can work. And now it should work. Please tell me, Yuri.
Yes,
Sure.
yes.
Okay,
yes,
thank you so much. So we've already heard an excellent presentation from Melinda on the legal background of GDPR-based slabs. And thanks to Bojana and Hazal, we've seen concrete and powerful examples of how privacy-based legal abuse works in practice and how it harms not just press freedom as an abstract concept, but the human beings who uphold it. What I can add to what's already been said is a fresh perspective, the perspective of a human rights organization that 6 years ago suddenly found itself facing a new kind of legal threat targeting public watchdogs and had to figure out how to respond strategically. So looking at our topic from this angle, I've identified 3 key points that are worth highlighting. First, how we see the GDPR, why it provides fertile ground for slabs, especially in Hungary, but also beyond. Second, what we hope to achieve through litigation, so what our goals are by using legal means. And third, what legal strategies we've chosen to reach our goals and how they are worked so far before the administrative and judicial bodies. So let's look at the first issue. And here as a starting point, let me take you back to 2019, even if it's not exactly a year we're eager to revisit, the year COVID first appeared. But in Hungary, it was also the year we realized that new data protection, that the new data protection regime introduced by the GDPR could be weaponized against media outlets and journalists. It was also the year when the concept of slap entered our radar and became part of our legal vocabulary. Because in Hungary, slaps didn't knock on the door directly, they slipped in under the cover of the GDPR. So what happened in 2019? That year, Forbes Hungary approached us with a problem they had never faced before. They asked for help because the owners of the famous Hell energy drink company, one of the richest families in Hungary, became furious about being included on Forbes' annual billionaire list. And these business guys, these bad guys, as you said, Yuri, didn't just complain, they threatened Forbes with GDPR-based legal actions. And this kicked off an exhausting series of legal battles that is still ongoing. Since then, since 2019, 2 other media outlets have come to us with similar concerns. Their logos are on the slide. Altogether, these 3 outlets have faced 9 factually distinct GDPR-based cases. And if I'm counting correctly, but maybe I can be mistaken, these have resulted in a total of 32 separate legal proceedings. It's hard to follow, actually, before various forums including national courts, the Constitutional Court, and the European Court of Human Rights as well. And many of these lawsuits are still pending. Instead of going into details of any of these legal battles, I'd like to sum up what we've learned from them, particularly about why the GDPR works as a perfect SLAP tool and what's the core problem with its application to journalism in Hungary. So as for the first one, what makes the GDPR a perfect SLAP tool? There are many encouraging factors, but I personally want to outline 5 of them. What I'd like to highlight first is that the GDPR has not just introduced new rules, it has also given people, including lawyers, a new lens, a lens through which they began to see legal problems as data protection issues, even in cases where such perspective hadn't existed before. Let's take a defamation case as an example. In Hungary, the level of data protection has long been high. However, before the GDPR, people typically reacted to false statements by only filing a defamation lawsuit. Now it's common to lodge a data protection complaint too, claiming that the personal data that has been published is inaccurate. The second issue is that the GDPR has created a new market for lawyers, and many have quickly learned how to use it. The third observation I want to point out is that the GDPR sets out clear-cut obligations, which make it a perfect foundation for rigid, technocratic, compliance-based legal reasoning that leaves no room for deeper consideration of fundamental rights. Another thing is that the GDPR opens parallel avenues for enforcement, while the relationship between remedies before the data protection before data protection authorities and the courts is uncoordinated and left entirely to the discretion of member states. And last but not at least, because this is the core problem, the GDPR gives member states broad regulatory leeway in striking a balance between data protection and competing rights or interests without any meaningful oversight. And this last issue brings us to what poses the greatest challenge in Hungary when it comes to applying the GDPR to journalism, namely the fact that the legislator has failed to introduce special rules that would relieve journalists from the administrative obligation the GDPR places on data controllers. And a key concern among these applications is the duty to inform data subjects before publishing, which amounts to a serious threat to investigative journalism. Another major issue is the disproportionate workload, the burden of informing data subjects one by one and proving data by data that there is a legitimate interest in publishing each personal detail. From the very beginning, we knew that knocking on the legislator's door would lead nowhere. The government, Viktor Orban's government, has no openness to dialogue with civil society, and our clients are all independent, critical media outlets, which in the eyes of the government makes them enemies as well. So this was never an option. Litigation was our only hope in striking down SLAPs. The goals that have driven our litigation have been quite ambitious. Beyond raising public awareness, we also have had two clear legal objectives in mind: to make room for press freedom within the GDPR framework by using various legal strategies, and to ensure that courts begin to recognize and name SLAP for what they are. As for the chosen strategies and their effectiveness, we have to admit that we could not bring SLAP into the vocabulary of the courts so far. it has its own explanation, but the core issue here is that claims in our cases are, so in light of the GDPR provisions, are not unfounded at all. So SLAPP is not a winning argument here, at least for now. But I can share some small but important wins by which we could partially reduce the administrative burden regarding to some categories of public interest publication. And those exemptions were achieved through various lines of reasoning. I start with the fact that our argument that news is a perishable good proven workable. It can justify the lack of prior notice under certain circumstances. We have also successfully pushed courts to recognize the lawfulness of data processing by journalists on a legal basis that doesn't require prior notice or a law objection against data processing. And the Supreme Court of Hungary showed openness to accepting this approach, depending on the article's topic. And finally, but yet importantly, the courts accepted that a general, not personalized online privacy notice can satisfy the requirements of prior information. The conclusions of what's been said concern the prospects for striking down GDPR-based SLAPP, both for Hungary and other countries facing similar challenges. Number one is that as long as lawmakers fail to introduce journalistic exemptions, the GDPR's administrative obligations will continue to pose an existential threat to journalism. Conclusion number two is more hopeful. We can say that the absence of explicit journalistic exemptions can be counterbalanced to some extent through carefully conducted strategic litigation. Thank you so much.
But thank you so much, Beatrix. Yeah, well, thank you also for your great work and all litigation. But yeah, it's kind of a battling ground in a way for trying to clarify this, the standards, this kind of tension between the right to protection of personal data and freedom of expression, and you now have a few cases before the European Court of Human Rights, so hopefully that may eventually lead to some clarifications and some better standards, at least from the European Court, so within the kind of Council of Europe system, and that kind of links me to one of the questions the audience about just international standards and how do they come into play if you don't have a sufficiently robust protection at national level. So yeah, I think we can probably say to that yeah, I think it's, again, the case law of the European Court of Human Rights isn't maybe where we would want it to be yet on this, and this specific issue, it hasn't been really rectified by the court. So this is something that will hopefully happen thanks also to your work to a great extent, because maybe it's going to happen in one of the cases filed by HCLU. But there is a broader framework, of course, that does exist, and it has been developed by the European courts, and of course it kind of leads the way, but this is the framework that is also applicable to Article 19 of the CPR, so it's kind of has this kind of more universal application outside Europe as well. And this is about balancing, there's no, under the European Convention, you don't have a kind of standalone right to the protection of personal data, but it's just part of this broader right to private life. And the court has a well-established case law on how those two kind of should be balanced, and before this data protection regime, it was kind of this balance was developed and refined in the context of defamation, but also in the context of clear breaches of someone's privacy when, say, kind of very personal photos are published, or just this kind of intervention into one's personal life. And data protection kind of has a much broader scope, as you pointed out. But that framework, that's kind of it affords greater protection to speech that is on public matters of kind of public importance that concerns public figures. So yeah, it's a broad framework that is applicable here as well. This is just to answer one of the questions, and I think we also had a question from which I would rephrase maybe somewhat. I'm not sure I understand, but I think it's more about the you have this legitimate interest exception in the GDPR. And is it something that can be useful as well and applicable? I mean, I guess it is applicable, but it's just that it has to be decided on a case-by-case basis. So even if you if you have a case, have an argument under that, you still can be dragged through a legal process, just to get to that solution. So it's not, again, this kind of slabs work. So it doesn't matter that you maybe indeed can use this protection. You have,
In Hungary, the Data Protection Authority resists to this kind of reasoning, but the courts show more openness to accepting the legitimate basis in terms of public interest. So, and as you said, it depends on the circumstances. Actually, what's the topic of the article? Is it really something of public interest? For instance, Forbes's billionaire list is not something that fits into this reasoning, because it's a kind of boulevard in the eyes of the courts, not a clear public interest publication.
Yeah, but I think also the problem with, again, here is that even if you do get a successful decision in the end, just it's just the burden of, this barrage of kind of legal suits and, the tool it takes. So this is how kind of slabs work, and surely now they are just particularly, this is kind of a new basis for them, and as you show, it's a very fruitful one, a very fertile ground for this type of action.
Yeah, that's true enough.
Yeah, so I think we are actually running out of time. So, and in terms of I haven't brought up all the questions, but I think that some of them are actually answered by our speakers, by the presentations, but also we need to admit that it's sort of kind of just scratched the surface here, because it's a complex issue in a complex area. So it's just good to put it on the map and just show maybe just kind of how you can kind of counteract it, what arguments you can use. But really, I think the main purpose of this conversation is just to highlight that this is a new threat, and if that will probably be this is a tool that will be used more and more, you know, I think just kind of globally, you know, and it has certain benefits, in inverted commas, compared to defamation, for example, or those other legal tools that, you know, different actors have been using against media when we just want to suppress, you know, the reporting they don't like. So, so that's kind of probably the main purpose of this conversation. But we'll share the presentations with all the participants, and hopefully that would also just allow, you know, everyone who's interested in learning more, just to kind of find some additional information.